You know, when you look at your budget, maybe planning the weekly shop or just your commute, the cost of energy, it's not just some abstract number.
No, it hits home, literally.
Exactly.
Yeah.
Gas pump, heating bill, it's right there. And today, we're diving into a document that actually argues those rising costs aren't just happening, they're being, well, deliberately driven up.
Driven up by certain environmental policies in specific states, according to this document.
Right.
And this isn't just an opinion piece, it's a formal presidential directive, Executive Order 12560. It was published in the Federal Register, so it's official.
90 FR 15513 for anyone wanting to look it up.
That's the one. And the title says it all. Protecting American energy from state overreach. It's basically setting up a legal fight, demanding action from the government.
So our mission today is to kind of navigate this whole thing. We want to break down the order, section by section, try to use clear language.
Understand its purpose, what it actually tells the government to do.
And critically, how exactly it claims these state policies are, well, costing families more money. Emptying your wallet, as the original script put it.
Okay, so let's start where the administration starts in the document. Section 1. It lays out the big picture goal.
Which is?
Unleashing American energy and achieving what they call American energy dominance. That's the frame.
An energy dominance. And when they say American energy, they're casting a wide net, right?
Oh yeah, very wide. It lists pretty much everything. Oil, natural gas, coal, hydro, geothermal, biofuel, critical minerals, even nuclear. All of it.
And the justification. Why is this dominance so important according to the EO?
Well, the order frames it as essential. A reliable domestic supply of all these resources is, and I quote, essential to the national and economic security.
Okay, so national security is tied to energy independence. Makes sense. But then the EO immediately pivots to a threat, doesn't it?
It does. Right away, it sets up the central tension. This goal of energy dominance is threatened, it says, when state and local governments regulate energy beyond their constitutional or statutory authorities.
So there it is. The federal versus state conflict aims squarely at environmental rules.
Exactly. Rules they see as, getting in the way of production.
Okay, so Section 1 sets the goal, dominance. Section 2 then points the finger at the problem, state overreach. Let's unpack that. What specific things are states doing that the IO says are harmful?
The order highlights three main methods, ways states are supposedly interfering improperly.
Okay, method 1.
First is discrimination. Basically, states targeting energy producers just because they're from out of state, creating, as the EO puts it, significant barriers to interstate and international trade.
Like protecting their own players by making it harder for others.
Precisely. Which, kind of goes against the idea of one big national market.
Yeah, if one state can just block energy from another based on where it came from, that seems like it would fragment things and potentially raise costs for everyone.
That's the argument. The second method they identify is using retroactive or arbitrary penalties.
Meaning?
Imposing huge fines, often looking backwards in time, penalizing companies for stuff that might have been perfectly legal when it actually happened.
Okay. And the third?
The third is states trying to control federal land. Basically, states wanting to call the shots on energy projects like siting or production on land that's actually owned by the federal government.
Stepping on Washington's toes, essentially.
You could say that, yeah. Trying to manage resources that aren't technically theirs to manage under federal law.
So this is where it gets, well, really interesting for people listening. How does the EO connect these legal fights, discrimination, retroactive fines, federal land disputes? How does it connect that to me paying more for gas or heating? What's the link?
Yeah, the EO is pretty direct here. It doesn't mince words. It says these state laws and policies are literally driving up energy costs for families coast to coast.
Okay, but how? What's the mechanism?
It ties back to supply and compliance costs. Think about it. If a big state, maybe an influential one, artificially restricts the national supply of something like natural gas, or if it imposes really, really expensive rules that companies have to follow, those costs don't just stay within that state's borders.
They get passed on, right? Baked into the national supply chain.
Exactly, built into the price everyone pays eventually. So a new environmental reg in, say, California, maybe designed to protect California's environment, could end up making fuel more expensive for someone in, I don't know, Nevada or Arizona.
Even if those states didn't vote for that policy.
Which leads right into the EO's core legal argument, federalism. The document claims these state laws undermine federalism by essentially exporting the regulatory choices of a few states onto everybody else. The argument is, you, the consumer in Ohio or Kansas, end up footing the bill for policies made way over in Sacramento or Albany.
Policies you had no say in.
Right. And that's the administration's fundamental justification for stepping in. They're saying it's unfair and disrupts the balance between states and the federal government.
Okay, so to back this up, the EO doesn't just talk theory. Section 3 dives into specific examples, right? Real-world case studies.
Oh, absolutely. And the language gets quite pointed here. It uses some very specific, let's say, charged examples to illustrate what it means by overreach.
Like what? Give us a taste.
Well, it calls out New York and Vermont, for instance. It talks about their climate change extortion laws. That's the exact phrase.
Extortion laws? Wow. What's the accusation?
The EO claims these states are trying to slap potentially billions with a B in fines on traditional energy companies, though the states might call them something else, like compensatory payments or damages.
Okay, billions in fines. But not just for emissions within their own state lines, correct? That seems key.
That's the absolute crux of the federal objection here.
Yeah.
The EO alleges these fines are retroactive, looking backward, and they apply to a company's past greenhouse gas emissions from literally anywhere in the United States and the world.
Anywhere in the world.
That's what the EO claims they're trying to do.
Right.
Now, it's really important to note, the EO views this as totally out of bounds, maybe illegal, definitely arbitrary, but the states involved, they frame these liabilities very differently.
How do they see it?
They argue these are necessary payments for historical environmental damage. Damage that, contributes to global climate change, affecting everyone, including their residents. So there's a massive legal and philosophical divide.
Yeah, clearly. But from the EO's perspective, these are arbitrary and excessive fines.
Correct. Then the focus shifts west to California. The order describes California as punishing carbon use by setting what the EO calls impossible caps on carbon emissions. It claims this forces businesses into these really expensive schemes, like having to buy and trade carbon credits just to operate under California's radical requirements.
And the argument is because California's economy is so huge.
Right. When an economy that size imposes a major compliance cost, it doesn't just affect California businesses. It sends ripples through basically every industry that has any connection to the state. Costs go up.
Okay, so New York, Vermont, California.
Right.
Any other types of state actions mentioned?
Yeah, it gets more general too. It talks about states just dragging their feet on approving energy permits, sometimes delaying reviews for years.
Which effectively blocks projects without actually saying no, a de facto barrier.
Exactly. And then, this is critical, it brings up lawsuits. States, or groups within states, using nuisance laws or other kinds of civil lawsuits, what lawyers call torts.
Suing energy companies directly for climate change harm.
Precisely. The EO warns these lawsuits could result in crippling damages. The underlying argument seems to be that states are using the courts, rather than legislation, to try and essentially bankrupt energy companies over climate change.
Knowing that ultimately the costs might get passed on to consumers anyway.
That seems to be the implication. So you put all this together, the global fines, the carbon trading, the permit delays, the lawsuits, and the administration's view is crystal clear.
What's the verdict?
These actions are seen as fundamentally irreconcilable with that main goal of unleashing American energy.
Yeah.
And the EO concludes this section really bluntly. They should not stand.
Okay, they should not stand. That's a pretty clear statement of intent.
Definitely. And it transitions perfectly from here's the problem to here's what we're going to do about it, which brings us right to section 4.
The mandate.
The action plan. What does the executive order actually command the federal government to do?
Well, this part really zeroes in on one specific office. The Attorney General, the AG, head of the Justice Department.
Okay, what's the AG supposed to do? The order says the AG must act expeditiously, which means fast, no delays, to identify state laws, regulations, policies, even ongoing civil lawsuits.
Identify them if they are.
If they are, or even might be, unconstitutional.
Yeah.
Or if they're preempted by federal law. Or if they're just otherwise unenforceable.
Preempted. That means federal law already covers this area, so the state law doesn't count.
Basically, yes. Federal law is supreme in certain areas. If Congress has spoken clearly on a national issue, a state generally can't make a conflicting law. The AEO wants the AG to find those state laws and challenge them.
And does it tell the AG where to look first? Any priorities?
Oh, it gives the AG a very specific checklist, almost like a target list for legal action.
Let's hear it.
Top priorities for identification include state laws that claim to address climate change, Also, laws involving ESG initiatives, that's environmental, social, and governance factors.
Right, ESG, we hear that term a lot now. What else?
Environmental justice initiatives are on the list too. Policies targeting carbon or greenhouse gas emissions specifically, and laws that set up funds to collect carbon penalties or taxes.
Wow, that's pretty comprehensive. It covers a huge amount of state-level climate action.
It really does. It seems designed to challenge the core of many existing and probably future state climate regulations, particularly in more progressive states.
So identify these laws, then what? Does the AG just write a report?
No. The directive is much more aggressive. Once the AG identifies these laws or actions as potentially illegal or unenforceable, the order commands the AG to take all appropriate action to stop the enforcement of them.
Stop the enforcement, like go to court and get an injunction.
Could be injunctions, could be filing lawsuits, challenging the laws directly, intervening in existing lawsuits, basically using the power of the federal government to halt these state actions. It specifically mentions stopping the continuation of civil actions.
So the federal government potentially stepping into state courts to shut down lawsuits against energy companies.
That appears to be exactly what the order directs the AG to consider and, where appropriate, to do. It's a very assertive stance.
And is there a deadline? How quickly does this need to happen?
Yes, there's real urgency baked in. The AG has to report back to the president within just 60 days.
60 days. That's fast for government action.
Very fast. And that report isn't just about what they've done. It also has to recommend if more action is needed, maybe further steps by the president, or even asking Congress for new legislation.
Suggesting this is potentially just the first step in a longer campaign.
It certainly signals an ongoing effort, not just a one-off order.
Okay, so let's try to wrap this up. What's the big picture takeaway here? What does Executive Order 14260 really mean?
Well, if you synthesize it all, it's basically a very strong move by the executive branch to assert federal power over energy policy.
Pushing back against specific state environmental and climate rules.
Exactly. Rules the administration clearly sees as economic roadblocks, barriers preventing the country from maximizing its domestic energy production. That's the core objective driving this.
So what this really does is set up a direct, potentially very public confrontation, doesn't it? Between the White House and several states, particularly states like California, New York, others active on climate change.
Absolutely. It's a fight over who gets the final say on national energy policy direction and how environmental costs get handled. The EO clearly argues that federal energy goals should take precedence.
And the justification used in the order is that these state actions undermine the equality of states, essentially letting a few states dictate costs for everyone else.
That's the claim.
So maybe the final thought for you, our listener, to chew on is this. The EO pushes hard for American energy dominance, prioritizing maximum production. How does that goal square with the unique environmental situations, the different energy needs, and frankly, the distinct climate goals that individual states might have?
That tension between national ambition and state-level priorities, that's likely where the legal battles will happen, in the courts.
And maybe eventually where the impact shows up on your utility bill or at the pump. It's definitely something to watch.